My predictions on the 11/22 hearing on the Delphi murders case. Right now, the case is only set for a hearing on the continued sealing of the records. But in criminal law, every hearing has the potential to turn into an anything goes sort of event, kind of like what I envisioned the Wild Wild West was like back in the day. I predict 4 things happening at the 11/22 hearing, and here they are. Number 1, the continued sealing of the records is going to be addressed. Before recusing himself, Judge Diner set a public hearing on whether or not to continue to seal the records in this case. The law in Indiana requires open records. The justice system is based on transparency, and that includes free and open access to the court and the court records. And that's not just my opinion. This is the law in Indiana. Now, this is a little long, but I want you to stay with me. There's some really good stuff in here. A fundamental philosophy of the American constitutional form of representative government is that the government is the servant of the people and not their master. Accordingly, it is the public policy of the state that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. Providing persons with information is an essential function of representative government and an integral part of the routine duties of public officials and employees, whose duty is to provide the information. This chapter shall be liberally construed to implement this policy and place the burden of proof for non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect and copy the record. It's a mouthful, but it's awesome. All records are free and open. That is the starting point. If this is the law, how are these records sealed? As with most things in the law, there are exceptions. And here is that exception. Indiana law says that before records can be sealed, there needs to be a public hearing to see if the following criteria are met. Side note, if the law says a hearing has to be held before the records are sealed, how is the hearing being held after the record is sealed? Let's ignore that because I have no idea. Here are the factors that a court may consider as to whether or not to seal a record. Again, a lot of talking, but stay with me. Number 1, a public interest will be secured by the sealing of the record. Number 2, dissemination of the information contained in the record will create a serious and imminent danger to the public interest. Number 3, any prejudicial effect created by the dissemination of the information cannot be avoided by any reasonable method other than sealing a record. Number 4, there is a substantial probability that sealing the record will be effective in protecting the public interest against the perceived danger, and it is reasonably necessary for the record to remain sealed for a period of time. Again, a lot of talking, but those are the ways to get around the open access to records. But the way this is written, all 5 of those must exist for the record to be sealed. And if any one of those 5 is missing or doesn't apply, the records don't get sealed. Now, I can see 2 distinct public interests in this case. Number 1, it might be really difficult for the family of the victims to have every single person in the world know exactly what happened to the victims. This case has international interest and everyone wants to know. I can't imagine how difficult it must be for the families to have to deal with this and having to continue to deal with this. It's got to be hard. The second public interest would be that unsealing the records could jeopardize the investigation into other suspects. Now, element 2, the danger to that public interest by having the information available. Well, there's no danger to the families now that Richard Allen is arrested. The details might be unsavory and they might be traumatic, but it's not dangerous. In my opinion, the public interest related to the family stops right there. Now, as to other people being investigated, we want to catch criminals as a society. If we give out too much information, other suspects might catch on they're being investigated. I think this might be enough to fulfill the second element. So we're going to go on to number 3. The third element. Are there other reasonable methods that don't involve sealing? Yes, they can redact information from the police report, probable cause affidavit, so it doesn't tip off other suspects. And this happens all the time. Oftentimes when there's sensitive documents filed, there's a public file and an official file. And the public file has certain information redacted, such as witnesses' street address or phone numbers. As a criminal defense attorney in Indiana, this is something I see every single day. There's no need to seal when redacting is more than sufficient. Even if there are other suspects, sealing is not necessary and completely overboard. Since it is unlikely all the requirements to seal a record exist, I predict the judge in this case on the 22nd will unseal the records and ask the prosecutors to redact things they don't want public to know. The second thing I see happening on the 11/22 hearing is the defendant is going to ask for a bond hearing. Online records indicate there's a $20 million bond, but other reports indicate there is no bond and the online records are just incorrect, which is terrible considering the actual court records are sealed and now the online records are just wrong. When an accused person is charged with murder, the Indiana Constitution says they are to be held without bond. Not having a bond in a murder case this early is actually normal and required by the Indiana Constitution. Now, the attorneys for the accused can ask for a bond, and the court is required to set it for a hearing. A bond hearing for a murder charge is unlike any other bond hearing. First off, when a criminal defendant is charged with murder, the burden lies with the state to show that the proof is evident or the presumption strong that a murder occurred. A bond hearing has been described by the Indiana courts as almost like a mini trial. The state only has to prove that the proof is evident or presumption is strong that the accused committed murder for a murder bond hearing. And they only have to prove it by preponderance of the evidence. Preponderance of the evidence is a very low standard, and it's nothing close to the standard of proof required for a criminal conviction. Is it more likely than not the accused committed murder? And if it is, then there's no bail. Now, I'm going to be very honest here. I don't think Richard Allen is going to get bail. It's just not very likely. And if he asks for a bail review, it's not going to happen on 11/22, the actual review. So if he's not likely to get a bond, even if he asks for one, why bother doing a bail hearing? Well, since 2013, the state of Indiana has to basically show their cards at a bail hearing on murder cases. This has turned murder bail hearings into an excellent discovery tool for the defense. The defense can get a little flavor of what the state has and test how the witnesses come across. The bad news is the state is not limited at trial by what they used at the bail hearing. So if the state sees problems at the bail hearing, well, they can fix those for the actual trial. So asking for a bail in a murder case is a double-edged sword. The accused gets to see what the evidence is, perhaps a little bit earlier than normal, and they can try to spot holes, but the state can also fix problems with their evidence and actually be better for trial. But when facing a murder charge, you don't really have too much to lose. So it's my position, why not try it? Since it appears that felony murder has been charged against Richard Allen, I don't see a downside to making the state show their cards on why they think Richard Allen was involved in another felony when these victims died. It actually might even be more important if Richard Allen is not the only person involved in the death of these victims. The third issue I anticipate being raised at the 11/22 hearing is venue. I would be shocked if the attorneys didn't file a motion for change of venue. The Indiana Constitution demands a fair and impartial jury and that the trial occur in the county where the crime occurred. But if the client isn't going to get a fair trial in the county where the crime occurred, there's a mechanism to get the trial out of that county. And that mechanism is Indiana Criminal Rule 12. There is zero chance Richard Allen gets a fair trial in Carroll County. Think about it. If Richard Allen goes to trial, he'll get 12 jurors from Carroll County. And if those 12 jurors find him not guilty, their life is going to be terrible. Think I'm overreacting? The judge who recused himself has called into question his safety, the safety of Richard Allen, and has compared the public's interest in this case to a bloodlust. Asking for a change of venue seems like an absolute no-brainer. And the defense attorney, with a certain exception, only has 30 days from the initial hearing to ask for a change of venue. The initial hearing was held back in October. Time is against them. The defense attorneys need to get the trial out of Carroll County as there is zero chance Richard Allen can get an impartial jury. The fourth issue I see being addressed at the 11/22 hearing is figuring out where Richard Allen is going to be kept at. The defense attorney must be able to communicate with Richard Allen. Some county jails have video jail visits, which can make preparing for a trial so much easier if you don't have to travel to the jail, wait in the lobby, be transported to the client, talk with the client, wait for the jailer to come pick you up, and then drive back to the office. Quite frankly, my office typically won't even represent people who are being held in jail pending trial unless they are in a jail that has video visits available for the attorneys. This switching of the jails that Richard Allen has endured has got to be terrible for preparing a defense. And then every jail has different procedures on how to visit. It just makes it a nightmare. He has to be held at one spot. And by having him at one spot, that's going to ensure that he's going to have a fair trial and perhaps avoid having to do the trial again. So those are my predictions. The court will unseal the record. Defense will ask for a bond review. The defense will ask for a change of venue. And the defense will ask that Richard Allen be kept at the same facility pending trial. It's important to remember Richard Allen is innocent until and unless proven guilty at trial. If you agree with what I've said, subscribe and leave a comment. If you disagree, well, that's awesome too. Subscribe and leave a comment. But But most importantly, remember, always plead the fifth.